Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. The sordid history of the tobacco industry is well known, with decades of misinformation leading to disease and death for millions. To curb this malicious behavior, federal regulations were enacted to control what tobacco companies could say, restricting any positive claims about their products. And here's the catch for the U.S. vaping industry. In 2016, the FDA deemed nicotine vapes as tobacco products, which means the industry is prohibited from telling consumers a critical truth: that vapes are less dangerous than cigarettes and could help smokers to quit. Joining us today to discuss this conundrum is Jim McCarthy, president of Counterpoint Strategies, an agency of record for American vapor manufacturers, the AVM. Jim, thanks for joining us again today on RegWatch.
I'm glad to be here.
First, I should make a comment about my voice. It is a bit rough. I developed a polyp on a vocal cord over the summer, and it's been a real challenge shaking it, but I do press on. Jim, before we dive into the big news you had to share about a major effort to push back against these regulations, could you first outline the industry's dilemma around free speech?
The fundamental challenge is that the federal government prevents vape manufacturers and retailers, vape businesses, from telling the truth to the customers that vaping is vastly safer than smoking and that it's the most effective way to help people quit cigarettes. And if we were to make those kinds of assertions in our interactions with customers on our websites, for example, or at a shop counter or in any kind of commercial speech, the federal government, the FDA, would step in and levy all kinds of legal sanctions against us. We're forbidden from saying those things, and we face severe civil and possibly even criminal penalties if we do.
The two most important things, are they not?
Yeah, I mean, it's crucial. And those are often the first questions that consumers ask when they interact with us. I mean, you could talk to any vape retailer and they'll tell you when people approach the counter and want to purchase the products, those are the questions they want to ask. And we have a fundamental right to discuss that with them. And the First Amendment protects that. And yet we are strictly forbidden from doing so by the FDA. We can't even quote what the FDA itself says in answer to those questions. And so it's a really extreme kind of muzzling of speech, and one that, impacts the entire industry and has had, I think, a, horrendous impact on consumer understanding and the free flow of truthful information, and has harmed public health too.
Yeah, I think it's best to describe that as the two things are comparative risk statements and then making any connection to smoking cessation.
Yeah, that's right. That's right. And there's there's a lot of nuance to the different kinds of claims that we can make. Some are regarded as health claims, and some are regarded as therapeutic claims, and there's regulatory minutia about which category those fall into. But the bottom line is we are forbidden from saying those truthful things that the FDA itself acknowledges are true, things that FDA leadership itself has said publicly. And of course, citations that are publicly presented and published and appear in peer-reviewed, esteemed journals of scientific literature and research, we can't even quote those. And so it's a sweeping prohibition on speech taken as a whole.
Now, this exists because obviously the tobacco industry lied for many years about the safety of its product. Is it fair that those constraints are being applied to vaping products?
Well, the regulations here largely fall under the Family Smoking Prevention and Tobacco Control Act, which was enacted in 2009. FDA deemed subsequently that vaping products are tobacco products. And so as a result, vaping falls under all of the same restrictions about commercial speech that the tobacco industry um, has has been under also. But it's important to understand that the federal government restricts commercial speech and health claims about all sorts of products, pharmaceutical products and food products and dietary supplements, for example. So there's a, laundry list of ways in which FDA and other agencies too restrict what companies can say and commercial speech. So although the tobacco companies, yes, deceived the public and said, wrongful things that were adjudicated, the that doesn't justify, I don't think, and doesn't fully capture the real breadth of the ways in which the federal government tries to control and restrict commercial speech.
It's interesting that the FDA's almost the raison d'etre for the agency is a speech police because it polices marketing.
Yeah, it's curious, and this is part of, I think, a longer political project that's been going on at the federal level for many decades. This idea that individual Americans can't really be trusted to sort out, competing views, and that they're easily, deceived or gullible, and that it's up to the federal government to be the choke point of what information that they get. And this is backed up, is based, I think, on a huge body of research in the communications theory world, that warns that ordinary individual people can't really be trusted to make up their own minds or sort through information without the help of experts.
Comparing risk between smoking and vaping, you aren't allowed to compare any product to smoking, so to speak. So that means that if you were to say that vaping is as bad as smoking, that's actually against the law, technically, in Canada. However, anti-tobacco and anti-vaping groups make those comparisons all the time. It seems that everyone can make a comparison as long as it's negative towards vaping.
Yeah, well, certainly. There's no restriction at all on what, I don't know, Michael Bloomberg and his various front groups can say. No claim is too tendentious. No accusation is too, caricatured to restrict them. And you know what? That's fine. That they ought to be able to say those things. And that too is a part of our, individual liberties and is protected by the First Amendment. And the remedy to that is to confront it, refute it, and, have that argument in the public discourse. But it's a good example, that imbalance, right, that exists right now in the way the law is applied, that, the activists that are hostile to tobacco harm reduction have the free run of the entire world of speech, including fiction, fantasy, hyperbole, and deceit, while the THR community, and vape manufacturers in particular, are prevented from saying things that are demonstrably true, that the FDA itself articulates. And so that imbalance has prevented the public from having a full, fair, open, robust debate about this, and, understanding the issue in a holistic way.
And that is so true, Jim. In 2012, 13% of adults incorrectly believed that e-cigarettes were as harmful or even more harmful than smoking. By 2020, that number had skyrocketed to nearly 65%. I mean, it keeps just getting worse.
And that includes a majority of physicians, I hasten to add. I mean, the wrong information and the wrongful understanding of comparative risk is, to borrow a word from the FDA, at epidemic proportions. And, don't forget too, Brent, I think a lot of the blame here has to be laid at the feet of the national news media too. They have a special trust in our society, to examine these important issues, especially ones of, public health, shoot straight with the public, cover both sides fairly, objectively, in a balanced way. And they have completely abandoned that. And the coverage on this topic has been, nothing short of malpractice. So it's a combination of both the way the federal government has throttled speech about tobacco harm reduction and the news media's failure to either hold the government accountable or present a full and accurate picture of what's happening in this discourse. And that's why, a broad plurality of Americans wrongfully, falsely believe that vaping is as dangerous as smoking.
I should say that one of the things that contributes to the issue with the national news media is that the industry is unable to spend dollars on advertising on those media platforms. And if you were able to do that, that does tend to soften a newsroom's particular attitude towards something. Look at pharma.
I guess, that's a tempting thought, although I have a hard time thinking that the national press would ever show any kind of sympathy for tobacco harm reduction. I mean, I think, we've seen over the last number of years that we've been working with AVM, the journalists that are covering this space, nicotine policy and tobacco harm reduction and, FDA, they have the same hostility for vaping and for THR that, the most strident zealots in the Bloomberg network do. They're not simply collaborating with those activists for, reasons of convenience. They share the same ideology. And, I somehow doubt that even if we had a full page ad running every day in the Wall Street Journal, let's say, that their reporting would ever lift up above rock bottom horrible.
So, Jim, we had the so-called teen vaping epidemic explode in the media in 2018. Then in 2019, the so-called vaping-related lung illness smashed any positive perceptions the public may have had about vaping. How did these regulatory speech restrictions hamper the industry's ability to set the record straight on these two issues?
Well, it's a combination of the two factors we just talked about. I mean, we are legally forbidden from speaking plainly to our customers and saying that vaping is safer and helps you quit. But in addition to that, FDA and the Centers for Disease Control and the national news media were hyping both of those phenomena, often in ways that were manifestly untrue. I would even go further and say willfully deceitful. And this is part, I think, of a really troubling hubris in public health, where authorities will shade the truth, omit key facts, amplify harm, and maybe even straight up deceive if they think they're going to get the broader public to some better, higher ground that they would like to see as the outcome. And that's a terrible Faustian bargain that public health indulges itself in. And you can see in lots of the communication they did, in and around COVID, for example, where they're now issuing mea culpas and lamenting how public trust has cratered in public health. That's a direct result of the exact same kind of hubris, lying to the public in order to get them to do something that you wish them to do. And you see that in the Valley case and in the teen vaping also. Valley had nothing to do with nicotine vaping. I repeat, zero connection with nicotine vaping, and yet they put it in the title. They made a deliberate decision about it. They went on the air and briefed reporters on that basis. And even to this day, CDC will still not shoot straight and say that Valley had nothing to do with nicotine vaping. And why? Of course, because their aim is to try to deter people from vaping. And if this can help scare people out of doing it, well, okay, you got to crack a few eggs to make an omelet is the moral calculus. And it's just horrendous. I mean, the harms from that to public health, public trust, our values as Americans, and the First Amendment itself. It's unspeakable.
I think that's a perfect example of this paradox, or this the screw that's being twisted on the agency is that like you've got E-Valley happening, but the industry can't actually buy media to set the record straight. And I think that's horrible.
Yeah, and don't forget too, the industry's under enormous financial pressure. I'd love nothing more than to have, Michael Bloomberg's $800 million budget to, do vape advocacy. But the reality is most of our members are, are facing bankruptcy and, don't have the wherewithal to do full page ads or, infomercials or any of the other kinds of advertising you're talking about. I mean, what we'd like to be able to do is say across the vape counter, hey, these products are vastly safer than cigarettes. They'll help you quit smoking better than any other method. I mean, that I think would be a game changer for the industry.
Jim, tell us about the legal challenge being launched to fight all this.
Well, this is really crucial because for a number of years now, eminent legal scholars have been writing and thinking and talking about the ways in which these restrictions on commercial speech about vaping are unconstitutional. And there's a huge body of jurisprudence in the federal courts on these issues about whether and to what extent the federal government can restrict commercial speech. And most of them are saying in this aspect, the federal government and FDA has gone so far beyond the bounds of what has been established by the federal courts as permissible under the First Amendment. And so AVM has spent the last 6 months, maybe a year even, carefully researching this, gathering focused input on the legal issues and the history of it, and lining up plaintiffs. And we are now ready and poised to take the Food and Drug Administration to court.
You had shared with us an excellent position paper by Jonathan Adler and Jacob James Rich titled Speech, Regulation, and Tobacco Harm Reduction. Tell us about the authors and this paper.
John Adler is a professor at Case Western Reserve University School of Law, and he specializes in environmental law and administrative law and constitutional law. And he is one of the most widely cited legal scholars in the federal courts and at the Supreme Court. He's one of the most highly esteemed legal thinkers in the country. And he's a regular contributor to a variety of national public affairs publications. One of the single smartest constitutional law professors in the country. And Jacob James Rich is a policy analyst at Reason Foundation, and he's a PhD student at Case Western in their School of Medicine. And he focuses on healthcare policy and drug regulation. And one of the single smartest people I've ever met on these issues. And they co-authored a paper in the Journal of Free Speech Law that details all of the legal background and the way that the Supreme Court would likely look at this, and the fundamental basis for this kind of case. And we'll put that link in the comments for you.
Yes, let's take a listen here. We've got a soundbite that you provided, and that's available up on AVM's X threads. I miss saying Twitter. And so let's have a listen.
If one looks at the way the FDA has been handling these applications, it's been arbitrary, it's been sloppy, it hasn't followed its own guidances about how it was going to review these applications. It's pretty clear that the FDA was not prepared for this onslaught of applications. But even if products are approved, there are challenges remain in terms of marketing products to consumers, communicating to consumers what the value of some of these products are, particularly in terms of harm reduction. Every time this sort of survey work is done, we see similar results. Here, 63% say that electronic cigarettes are as or more dangerous than combustible cigarettes. It's tempting to blame this on events of the last few years, to blame this on the mishandling of the EVALI controversy by the CDC in particular, the failure of the CDC to identify or acknowledge where these lung injuries were coming from. And certainly there were some polls done right in the wake of the dramatic increase in lung illness that suggested that the EVALI outbreak was part of the reason so many Americans, including so many smokers, believe that electronic cigarettes are as or is not more dangerous. In the case of nicotine products, we can think about the wide range of things that might cause people to choose one product or another. And I'm sure if we sat around, we could add 20 more product characteristics to this list that help consumers choose: price, convenience, flavor, so on. Health is off the table, or at least off the table without permission. And that dramatically restricts the extent to which, at least in the United States, that companies can compete with each other in trying to communicate to consumers that their products offer safer alternatives to combustible cigarettes. They can't compete with each other in trying to convince smokers that their product will satisfy the desire for nicotine and whatever else, but also do so in a less risky way. And that's a problem. The FDA's position is that producers of electronic cigarettes can't quote things that Brian King said here yesterday, can't quote things the FDA has put in the Federal Register that are indisputably factually true. And if they say things like, this might help you quit smoking, well, then the FDA's position is forget modified risk tobacco product, that makes you a drug device. And there's a whole different approval process you have to go through for that. So we have a statute and its implementation that are preventing the use of the most powerful way we know how to educate consumers, to discover how to educate consumers' behavior, and to influence consumer behavior in a more positive direction. Supreme Court has said repeatedly that courts should be especially skeptical of regulations that seek to keep people in the dark for what the government perceives to be their own good. And that includes attempts to deprive consumers of accurate information about their chosen product. We're not talking about sensational claims about unproven medications or unproven treatments. We are talking about claims that the FDA itself acknowledges are true.
And I think that's probably the most powerful part of the argument, is it not, Jim?
It is. And that's the first thing we did in our research, is we gathered all of the key salient statements that the FDA had made at public forums and in the Federal Register and on the record and in published works. And we compiled all those together. And that's going to be the centerpiece of our case. We're going to go to a federal court and we're going to say, behold, these are all the things that the FDA itself says and are demonstrably true, and we wish to either repeat them or quote them. So there's no dispute over whether these things have, veracity and scientific basis at all. It's things the FDA itself acknowledges are factual.
Would the regulations have to get rewritten eventually, or can it just be a court ruling?
Well, ultimately the Supreme Court, if it would likely go, all the way to the Supreme Court. And at that stage, they would restrict the FDA from doing it. So the FDA would have to, in its application of the Tobacco Act, the Supreme Court would have, the FDA would have to refrain from restricting speech in this fashion. That would be, unlawful going forward. It would not, a Supreme Court ruling would not invalidate the law, but rather the way that the FDA was interpreting and applying it in terms of commercial speech.
Would the science on vaping get an opportunity to be litigated inside this legal challenge?
It's curious. There's been a lot of speculation about how the FDA will react to this kind of legal challenge. And we've lined up, I think, some pretty compelling plaintiffs. We've got AVM is going to be a lead plaintiff. We have ordinary vape shop retailers. We have manufacturers, which are mostly small businesses. And we have ordinary individual customers also who, will tell the court, we wish to be able to have this conversation with our vape shop. But how the FDA is going to tackle that, I think is really challenging. I don't want to seem overconfident, but it's hard to see what kind of leg they have to stand on here. They may they can't really argue, oh, vaping's more harmful than you might imagine, because again, we're quoting things that they said. And so it's tough to figure what their defense is going to be. I mean, another important thing to remember is that the federal government doesn't often get challenged on commercial speech cases. There's a terrific article that Adler wrote for the Washington Post, which we'll link in the comments, that goes through a lot of the jurisprudence on this. But you'll notice it's not all that frequently that major companies, confront FDA or the federal government writ large on commercial speech grounds. So it could be a really groundbreaking case here. And I don't know. I don't envy the attorneys at the Solicitor General's office who are going to have to litigate this for FDA.
So where are you in the process? Is your filing ready to go?
I'd say we are, to borrow an American football term, first and goal. We've got plaintiffs lined up. We have a terrific attorney with First Amendment specialization, whose name is Trey Mayfield. He's helping us coordinate the legal effort. All the plaintiffs are lined up, and the jurisdiction has likely been identified. But the tough part, again, to get back to what we were saying before, is the resources. AVM is a small trade association. We have members who are, facing eradication by the federal government, the full hostility of the National Press Corps, a $1 billion array of front groups funded by, one of the richest guys in the world. So our guys are already up against, really long stacked uphill odds. And so what the last piece of the puzzle for us is to raise some funding for the litigation. And that's, I'm going to be doing this pro bono for AVM. Our attorney, Trey Mayfield's also going to be working pro bono, but we still need resources for the legal expenses and the filing costs and travel and, all the other elements that go into a case. And of course, we would like to talk about it. It's a free speech case. We want to shout to the rooftops, hey, we're sticking up for the First Amendment here, and the right of every vapor and retailer to have truthful conversations. So we're putting that last piece in place, which is passing the basket for funding. Another way to think about it is everyone in the vape community, from businesses to consumers, to people who care about the First Amendment, can take part in supporting us.
Now, we've thrown up a QR code on the screen during this episode for people to donate. What kind of numbers, what should somebody consider, kicking in?
Well, the good news is that we don't need a gigantic budget for the project. The case is fundamentally very straightforward. And, we've got an attorney, PR guy, the great team at AVM are all going to be pulling at the same oars to get it rolling. So even small dollar donations would be most helpful. But if there are those with more means who want to give us, some heftier funding, that would be great. And I can hold out the hope that this would be an enormous game changer for the entire industry. And what's more, if we prevail, ultimately, likely at the Supreme Court, this would have sweeping ramifications for free speech law, not just at FDA, but across the entire administrative branch. It'll be the most important free speech case in the last 30 years, probably. And so there will be a day soon, not long coming, when we're on the plaza at the Supreme Court, having thwarted FDA, stood up for the First Amendment, the most important, free speech case in a generation.
Jim, it's October right now. How soon could our viewers expect this to be filed?
The last piece of the puzzle for us is to organize the costs that are going to fund the expenses and the court costs. And I'm optimistic that we can get that in place in the next couple of weeks. So the firm date is still to be determined, but we're expecting and hoping to file sometime in the next 6 weeks.
I want to bring the conversation back to the PMTA. We actually haven't talked about it much, but that process that's seen the denial, marketing denial orders, I think that's the key thing there. Right there, it's a denial to market, not to sell your product. So at its very heart, it is a free speech or no speech issue that the FDA is working with.
Well, I'll be curious to see what the Supreme Court says about that. I'm going to be attending the oral arguments in the Triton case. That's the Triton v. FDA case that the Supreme Court has agreed to hear. That's hugely important. Very few cases are granted cert and heard at oral argument in front of the Supreme Court. And you're right. I expect and hope that the justices are going to zero in on the ways in which the federal government has been, throttling these companies for arbitrary reasons. And you'll notice too, the FDA leadership has been unapologetic, almost brazen about all of this. There was a speech we'll link in the comments that Robert Califf gave recently, in which he trashed the First Amendment and said, things that seem so obvious to public health policies, might run afoul of, some people's fondness for the First Amendment, he said. Just this contemptuous tone that ordinary people who think free speech is important, get out of the way, you peasants. We know what's best for you. And it's obvious to me what ought to be done. So why are we letting, 200-year-old parchment like the First Amendment get in our way? I mean, things like that do not sit well with federal judges. And that's, if the FDA lawyers try to use that in front of the Supreme Court, boy, they ought to be wearing asbestos underwear. You can find all of the information about the litigation on our website, which is theavm.org. And we're going to have a lengthy thread that details all the particulars when we file the litigation. And we're also going to be live tweeting from the Supreme Court case when the oral argument is heard. So we'll have in-depth analysis of that as well. And not only, Brent, of the case itself, we're also going to cover the way that the national news media is covering the SCOTUS case. All of the major reporters on the FDA beat have so far ignored the fact that FDA is being taken to the Supreme Court woodshed. So we're going to try to talk to them about that. Why haven't you covered this? Why haven't you interviewed ordinary vapors? Where have you been all this time?
So take your last parting shot at the FDA for us, Jim.
Well, the part that troubles me the most is the attitude that the leadership there has toward both businesses that are trying mightily to help people switch from cigarettes and ordinary consumers and ordinary Americans who have a fundamental right to get truthful information about this. The agency itself has delayed communicating about the continuum of risk and shooting straight with the public about that. They just put out a $2.5 million grant to study whether and how they can simply shoot straight with the public about it in a national campaign. That's going to take 4 years to determine whether and how they ought to do it. As if that wasn't bad enough, they gave the grant to the Michael Bloomberg School of Public Health at Johns Hopkins, and they increased it from $2.5 million to, I believe, $7 million. So that's just a horrendous dereliction of duty that's contemptuous for the American people. Dr. Califf's remarks about, his disdain for the First Amendment, Brian King's central role in deceiving the American public about EVALI, in his apparent hope to try to steer their behavior, and their arrogance in front of the federal court, that they know better and that only experts like them should be able to decide. I mean, all of it just reeks with contempt for the most cherished values we have as Americans. I mean, there's a reason that's the First Amendment. It's the single most important component of the Bill of Rights. All of our other freedoms depend on that. And these guys are using it like, liner for their parrot cage. And it's got to be stopped. And what I like about, the litigation we're going to have here is, in a way, is it's small size, Brent. This is going to be small businesses, ordinary people, modern day Minutemen. If you'll indulge me an analogy, and we can all chip in, and we can all take part, and we can all have our day on First Street at the U.S. Supreme Court and stick up for the Constitution and our right to have truthful conversations with one another. And, there's nothing more all-American than that. So my message to FDA is, buckle up, because we're coming for you.